Thanks all for joining today for our training about Social Security insurance and Social Security disability benefits. My name is Tess Summer, and I'm the Program Manager for the Health and Housing Consortium. If you're new to the Consortium is a collaborative network of healthcare, housing, homeless, and social service organizations, as well as government partners with the shared goal of improving health equity and housing stability. We work together by fostering cross-sector relationships, informing policy, building the capacity of frontline workers, and bridging the gaps between the health and housing sectors. As part of this, we often host trainings for frontline staff across the various sectors about the state of housing, health services, legal options for clients, and more. So a few housekeeping items. As I already mentioned, everyone should be set on mute, so please refrain from unmuting during the presentation, but we'll definitely have an opportunity for you to ask questions directly to Anne once we get to questions. We do have live transcriptions available. To enable or disable them, click the closed captioning button at the bottom of your screen. And then if you have any questions that come up throughout the training, please enter them to the chat box. We'll try to get to them as they come up, but if we don't, we will absolutely get to them during the Q&A portion. And we also welcome you to enter any resources into the chat if you think of them. I will also be sending again the training slides as well as a session recording after this, so please be on the lookout for that. And our training today is led by Anne Callaghy, Director of Government Benefits at the Legal Aid Society. Anne is a big partner of the consortium, and we are so grateful for her. So thank you, Anne, for sharing this information with us today. And I'll let you get started.
Okay, great. So thanks everybody for coming. It's always a little weird in remote trainings to say, you know, thanks for coming, but we do anyway, sign on our computers. I've done this training or some version of it a number of times for the Bronx Consortium, and it's always a nice group to work with, and it's always a little different every time. And some of that, of course, in the last 2 years is because of COVID. So I'm going to be doing an overview that'll cover a number of things. One is, how can my client get help with an SSI application? How can my client appeal an unfavorable decision at any stage of their case? What if my client misses a hearing or an appeal deadline? Is there anything that can be done? What can my client do if they're told they were overpaid benefits? These are some of the problems that come up for, I think, your clients. And we'll talk about how to address some of them. For starters, I wanted just to give a list of contacts at Social Security, since a lot of, I think, what you do and what our staff does is try to solve problems. And that means you always need a way to contact the agency. So here's a list of useful links. The SSA.gov website is very good if you have a question about eligibility or how a program works. They, on SSA.gov, have COVID updates. Are offices currently open? How do you contact offices in COVID? That kind of thing. Here's the toll-free number. To get the phone or fax number of a local field office, there's the link for that. We also have a list of public affairs specialists who could do troubleshooting. You're trying to get through to a field office, you can't get anybody on the phone. Public affairs specialist job is to be a link to the field offices. So you can email them and say, I'm trying to reach the Hunts Point field office. I'm trying to reach the Concord Village field office, and I can't, and this is the problem. And we have found, at least pretty soon thereafter, somebody from that field office contacts us. The hearing office locator, if your client is trying to figure out where their case is going to be heard by a judge, is at this link. So it's just some helpful links. This is a list of the public affairs specialists appointed to the various boroughs. So the Bronx have 3 listed. One is, you see Ravi Gopal, Shirley Saxton, and Vincent Scocoza. We've been in touch with any of those 3, and they have been responsive. So it's good email addresses to have. These are online, so they are open to the public. So it's not like only advocates can email them. Clients could email them. So I wanted to share that with you. I wanted to talk about the differences, hold on. Yes, between SSI and SSD, which maybe you know, but is kind of worth stating, because eligibility, the non-medical eligibility requirements are different. SSD, as you probably know, is based on somebody's earnings history. So if you or I, who have a work background and paid into Social Security, became disabled and unable to work, we would get Social Security disability, also known as Title II, also known as DIB, Disability Insurance Benefits. It is a much more loose program than SSI, in that SSI is a means-based program. It's basically a federal welfare program for people who don't have a work history, at least on the books that they paid into. It's a poverty program, but it's a means of somebody who's too disabled to work to have basically double what a welfare grant would be. So it does allow for greater economic stability. It does entitle them to Medicaid, but it's restrictive in these ways. Any income, with certain exceptions, gets counted dollar for dollar against the SSI, earned or unearned. You can only have $2,000 in resources sort of in the world, right? And it doesn't matter if that's under your pillow, or if it's spread across a number of bank accounts, or if part of it is a life insurance that can be cashed in. All of those resources together can't be worth more than $2,000. And that includes people who have 401ks, like if they had a work history at some point and they paid into a retirement system, that's a resource. SSI is more restrictive also because none of my dependents can be paid on my SSI. Whereas if I get SSD, my children under 18, my spouse of children under 16 can be paid to support them. If I have a disabled adult child, they could be paid on my SSD benefits. My spouse could get survivor's benefits if they are disabled or when they retire or reach retirement age. SSI is just for the person. Also, SSI, the earliest date I can be paid is according to the application date. So SSD, I could apply and be paid a year prior if I can show my disability. I think somebody's not on mute, so just a reminder for everybody to mute. The SSI benefit amount is set by statute. So I can't get more than that amount, even, for any reason. The SSD, the amount depends on how much earnings I paid into the system. So if SSI is $794 a month, my SSD could be $1,200 a month if I paid enough into the system and worked long enough. There's a much more restrictive application method for SSI than SSD, and we'll talk about some of those.
And I have a couple quick questions for you.
Yes.
So in relation to the Social Security Administration contacts, do you have any idea? You might not, but in your experience, how Getting a little feedback. Please remain muted. Thank you. How long does it take to get a response from them?
Oh, when we go through the public affairs specialists, I would say within a week we hear from somebody, and I would even say within a few days. You know, I know you, that probably isn't uniformly true, but I have found that they're pretty responsive and it works. Because I think what they're doing is they oversee the field offices. It looks bad for the field offices to be found out to be not responsive. So they give them a poke and then you hear from somebody. So.
Okay, well, that must be a relief then for everyone.
It's good, yeah, yeah.
All right, back to you.
Okay. A note about how SSI and SSD programs are similar is basically they use the same definition of disability. So that is what a claimant has to prove, that they have a medical disability that renders them unable to do substantial work for at least 12 months. And that definition is the same for both programs. So you need the same medical evidence, the appeals process is the same. So like where legal aid does most of its work in getting people disability, the SSI SSD distinction is in a lot of ways not that significant, because if we're doing a hearing, we're doing one hearing for both and we're proving disability in the same way. But we are going to talk a little bit about this definition in greater detail in a few minutes. So how can a claimant apply for SSD and SSI right now? You can apply online much more easily for SSD than SSI, and we'll talk about that in a moment. There is something called a vulnerable population liaison that SSI has created this program to facilitate the applications of SSI recipients and applicants. I'll talk about that a little bit. A person can apply by phone. SSI says there is a shorter wait time if you call Wednesday through Friday. Okay, I'll believe them. A little more detail. Claimants can apply for adult disability benefits online if they meet the criteria in these lists, depending on the program. So you'll see that the SSI is more restricted. If you're between 18 and 65, if you've never been married, if you aren't blind, and the reason is there's a whole set of rules if the disability is blindness that are separate from other people. If you are a citizen residing in one of the 50 states or Washington, D.C., or the Northern Mariana Islands, if you've never applied for or received SSI before, if you are also applying for SSD at the same time, and you see, like there are a lot of ifs there, and many of our clients, they've applied before, or they used to be on SSI, and for one reason or another, the benefits were discontinued, or they have been married, or they are a child, so they're under 18. So there are a lot of reasons why a person couldn't qualify to apply online. Even if you begin the application for SSD online, you're still going to have to sign a paper form. So you begin it, they're going to send you a form to sign. When it's not COVID, they'll call you in for an appointment to sign the papers. But right now they're trying to still do most things remotely. For SSD, many fewer restrictions on online applications. You have to be 18 or older, not currently getting benefits on your own Social Security record, like retirement. You can't work, so you're alleging that you're disabled, and you haven't been denied benefits in the last 60 days. So it's a much looser, it's much easier to apply for SSD. The other thing that we are looking into is the fact that if you are a non-English speaker, there's almost no way for you to access an application or information to actually apply in your own language, even Spanish. And so this is, I think, illegal, and it's appalling. And so we're looking at that problem, but that's something you should be aware of if you're not.
All right, we have some questions.
Yes.
Okay. Is the vulnerable population liaison a national position, or is it New York specific?
You know what? It is a national program, but then they have specific people assigned in New York to work with us. And the whole reason for it is even Social Security was alarmed at the decrease in the number of applications being filed for SSI during COVID. So, and they knew this is bad. That even they did not believe it was because suddenly fewer people had disabilities. They knew it was a lack of access. And they knew that really they shut their doors, and maybe health-wise that was a good idea, but that people don't have technology. They don't have the ability to use technology. They don't so big barriers. So they created this vulnerable population liaison program. They will work directly with an organization who commits to helping take claims and providing SSI information, or to just let Social Security know that here is a person who needs your help. Legal aid and a lot of legal services organizations in New York City have signed up for this program, so that what we end up doing is sending an email to say, this person needs help. So far, they've said, send us the name and phone number and we'll reach out to take an application and follow up with that person. In general, it does say online, and this is the information I'm giving you in general, that Everett Lowe, who is a person that legal services, and maybe you guys have worked with for many years, who's a very responsive person, has this new position as the regional communications director. So he's kind of been promoted. You can email him at that email address to say, I have someone who needs a VPL to apply. And in the subject line, you should put VPL referral, because that will flag it for him, because they really are trying not to lose applicants who need assistance. Any of these suggestions I'm making, as you know, because you're advocates working in the community, the way things are supposed to work and the way they actually work, sometimes there's a big gap. So any of these things that you try, I would be interested to know if it works or not. And if it's not working, so you could email me. I think my last slide has my email. Or you could email Tess and she could email me. But I am happy to do problem solving. So if you find information here, you're just not getting through, we should know that, because Social Security should know that, and we could try to do some extra troubleshooting. I hope that answers the question. Does that answer the question?
I think so. Thank you so much. And there's someone in the chat who I think has been having a hard time making appointments for their patients. So Laura, if you're able to contact Everett, let us know if that helps. And someone wanted clarification. The subject line should be VPL.
Yes, Vulnerable Population Liaison, VPL.
Great.
And that's what Social Security has said, if we email them, to put it in there. If you are, this kind of addresses this next slide, I think, what you might be saying about appointments. And I see there are 62 messages in the chat. So
I'll give you one more question. A lot of messages in the chat are just people introducing themselves, but we had some confusion about permanent residents being able to apply. Are they not able to apply for SSI?
So one thing is that anybody should be allowed access to applying and get an answer, even if it's no, and have the right to appeal, right? So anybody should apply. Having said that, legal permanent residents can be eligible in a number of ways for SSI. If they have been in that status for at least 5 years, then they can be eligible as long as what I should say is that their immigration status should not be a bar at that point, right? They need to meet all the other eligibility criteria, like proving they're disabled and proving they don't have resources and income and stuff like that. So beyond 5 years. And then if they're a legal permanent residents and they don't have 5 years, but they're under 18, or they can show that they have 40 quarters of covered earnings, meaning they've worked 10 years on the books, then that their immigration status also would not be a bar to SSI. But you see how tricky that is. If I've worked 10 years on the books, but I haven't been a permanent resident for at least 5 years, then there may be some explaining to do. So I'm,
Got it. All right, no clear answer for that one. That's tough, but thank you. All right. Resume.
Another one? Resume.
We're good.
So, okay, so in terms of making appointments to go to their local offices, that is still very restricted because of COVID, because the field offices are not reopening to the public in a general way. If a person or if you feel that your client needs an in-person appointment, you can call the local office to try to make one. They will pretty much make appointments for people who can show a dire need. And I've listed essentially what that is here. So that's being without food or shelter, could be utilities, without medical care, or they need to reinstate benefits, or they need to apply and they can't do it any other way. If this continues to be a problem and you think your client fits this description, I think you could reach out to one of the public affairs specialists and name the problem and say, my client needs an appointment, and and in a way see what happens. But that's the next step I would take. After a client applies, or claimant applies online for SSI, basically the application, SSA will mail a notice with an interview. They will mail an application page to sign. And really, we have found that it speeds up the scheduling of the interview if you call about a week after you submit your online material to schedule the interview. So you follow up with them. As you might know, during the application process, Social Security gathers medical evidence. It's their duty to do so. They will often send our clients to consultative examiners. That's Social Security contracts with a panel of doctors. These, as you might know, are also not very in-depth exams. They don't last very long. They don't know our clients. They don't know their history. They have a set of cursory questions and tests they put our clients through. And then they write up reports, and that report becomes part of the Social Security claims file. Also, the case is sent to a disability analyst at the state agency, meaning the Office of Temporary and Disability Assistance, OTADA. And the disability analyst reviews the medical evidence in the file. And based on Social Security's rules and their analysis of the evidence, they make a recommendation for a decision to either grant the disability claim or deny the disability claim. As advocates, As advocates, we can help gather medical evidence and reports from our clients' doctors. That evidence can be sent to the disability analyst. Once a disability analyst is assigned to the case, even if we're not officially on the case, the claimant ought to get a notice that a disability analyst has been assigned, and there'll be a phone number. You can call that person. You can ask for their fax number. You can fax evidence to that person. You can speak with the disability analyst. And you can point out the strengths of the medical evidence. And, you know, we have had it where a disability analyst says, oh, I hadn't looked at that. I see what you're saying, and they grant the case. That doesn't always happen, but it has happened. You can be assisting a claimant in a variety of capacities. You can be an authorized representative, which means filling out an appointment of representative form. It's a particular form that we know of as a 1696. That can be mailed or faxed. It can also be done electronically online, though your client would have to have an email address that it would go to. You could also assist as not an authorized representative, but somebody who has permission for Social Security to talk to them. And the claimant can sign a consent for release of information, which says Social Security can speak to this person on my behalf. So it's like you don't have to be all in, but you can be in enough for Social Security to talk to you. Evidence includes.
Wait, Anna, I have a question.
Sorry. Yes.
Someone's asking if it's possible to have communications with. Because you said that SSA will mail the claimant a notice with an interview date.
Yes.
Is it possible to have that information emailed rather than like actually mailed? Because not everyone has a reliable mailing address.
That's a good question, but I think probably not. And that is because Social Security is concerned about confidentiality and your Social Security information being stolen over the electronic system. So whenever they mail us or email us information, it's all through an encrypted email system. So they're not really going to send that stuff by email, generally speaking. But I get why it would help. Yeah. But mostly they're not going to do it.
Okay, thank
you. Evidence that they gather and that we can help gather to the degree you're involved in the application are opinions about somebody's ability to work or function daily from a claimant's medical sources, doctors and nurse practitioners and psychologists and psychiatrists. Medical treatment notes from medical providers, hospitals, inpatient, outpatient, test results, all of that. Old school records become very important for people who have cognitive impairments. They might have been in special ed in New York City. There is a slide coming up about who and what address to use to request school records. And then sometimes people's housing records, if they live in a public housing setting, might be helpful in indicating how a person functions or needs help to function. Because if they're in supportive housing, if there are records of what assistance they get, maybe they get medication reminders or appointment reminders, or they have, other kinds of support, that all goes to show that they can't function independently. It is possible to obtain special ed records in New York City if a person went to New York City public schools, even for people who have been out of school for a long time and are over 21. At least at some point, I was working with she was about 52 years old, and she was diagnosed with mental retardation.
Saying that still?
And the term has changed now to intellectual disability. And I got her special ed records. And it showed that she had this low enough IQ since before she was 22 years old, and that's one of the requirements. So it's well worth getting. And this is the name and address of the person to whom you mail or, mail a notarized authorization form. I have a note here that judges' subpoenas are being prioritized by this office, and we know this is true because they've said it. So when our advocates are sending their own requests for records from this office, it's taking 6 months. I mean, it's just, I think it has gotten much worse over COVID. They didn't used to have hours restricted to 3 days a week, that kind of thing. So if we're at the hearing level, we are routinely asking the judges to send a subpoena because the office has said we're going to pay attention to the subpoenas from judges before we're paying attention to the requests of ordinary citizens like us. So it's worth making the request, however, since it does take time. Is there a question?
There's a question.
Okay.
What should we enter on the SSA consent form as the reason the client wants the information released?
I should look at the form itself. In our office, we say possible representation in an SSI claim. You could say assistance with an SSI claim. Yeah.
Great. Thank you.
It doesn't have to be all that technical and things like that. Yeah. Though that makes me want to say the first time I had to fill out a 1696 appointment of representative form, I found it extremely intimidating. And I was like, what does every field mean? And a person at Social Security who was walking me through it did sound like, I was being silly. But I know that all of these official forms, if you've never filled one out, there's no intuitive reason why you would know what should go in the fields. If the application is denied, Social Security is required to send a notice of determination. If it's approved, they're required to send a notice of approval. That notice contains the appeal rights and the deadlines for appealing. And so I just wanted to outline how a claimant can appeal a decision, and especially now in COVID. In general, there are 4 levels of appeal. So if an application is denied at the initial level, the appeal goes to the field office, and it's called a request for reconsideration. Everything, as you see, more or less has a form number attached to it. This can be done online at the link given. If a reconsideration has been denied, a person has the right to request a hearing by an administrative law judge, and that also can be done online at the link given. If a hearing results in an unfavorable decision by a judge, a claimant has the right to request review by the appeals council, which is also part of Social Security, and that can also be done online at the given link. When you go to the link, you'll see you have your choices: a reconsideration, request a hearing, request review, under something called iAppeal. Now, the requests can also be made by fax. For the reconsideration, it would be a fax to the field office. For the hearing, it would be a fax to the hearing office. For the appeals council, it would be a fax to the appeals council. If you can do it electronically, it's much more reliable because once you've done it electronically, you have a receipt and you know it's in their system. Faxes get lost. Faxes don't get picked up off fax machines. You'll get a receipt, but you may find yourself arguing down the line that, no, I sent it. What do you mean you never got it? So if you can do it electronically, that's preferable. If you can't, you can do it by fax. You could mail it to the local office. So doing it one way is better than not doing it at all. But time limits for appealing at every level are the same. It's 60 days plus 5 days from the date of the denial notice. So we tend to think of it as 65 days from the date on the denial notice. It's a hard and fast deadline. It's a statute of limitation. If you blow the deadline, they'll say you're too late. But there is in Social Security's rules the notion of good cause. So what good cause do you have for being late? And clients have all kinds of reasons. And one thing I would also emphasize that in COVID, Social Security has explicitly said they are being much more flexible with granting good cause because they know that systems haven't worked well either. So you can look at any circumstances. I didn't get the notice. I got the notice late. Social Security knows, especially in COVID, the mail has been terrible. My disability prevented me from understanding what the notice meant. My disability prevented me from taking action, even though I knew what the notice meant. It is recognized that, depression and behavioral disabilities impair somebody's executive functioning, right? Their ability to make decisions about what they need to do next. And so it is possible to say, because of my disability, I was late. And Social Security gives you the opportunity to make a statement in writing. You as the advocate and the claimant to say why they were late. And then they get to decide whether or not to grant good cause. And we are finding in COVID, they're granting good cause. So I would find it outside of COVID, they granted good cause too when it existed. And so if it's not 2 years after the deadline, and it's not that far from the deadline, it's worth appealing. So the other option would be to reapply. But you do lose the possibility of winning that application. Is there another question?
Did you cover hospitalization? If that's a valid reason for delay?
Oh, I didn't say that, but it is.
Great.
So I want to say, where I say, did circumstances cause delay? They do in their regulations, Social Security give examples of things that would constitute good cause. But really talk to your client and say, like, what's the story? Because whatever that story is going to be our argument for good cause. So I was in the hospital. I was sick. I was caring for someone who was sick. I was, temporarily out of the state because I had a relative who died. I was, like, whatever it was. So whatever the circumstances are, tell the facts. And the more specific, the better, because it just adds to the credibility of why the person was not on time.
And how soon after being denied can you reapply?
If you don't appeal, you could reapply right away. But you don't get to appeal and reapply. That's one thing. So you're choosing which way to go.
Okay. And if someone wants to know what's better, appealing or reapplying?
I mean, I would almost always say to appeal. With some exceptions. If that first application was based on very thin evidence and not that strong of a disability claim, and then it was denied. And then my client was in a car accident and was extremely more disabled after that. That's a brand new condition that really had nothing to do with the first application. I think I would say just reapply. because you'll probably be granted on that second one. And the likelihood of being granted on the first one is very slim. And it'll happen more quickly because the application process takes a few months. The appeals process can take years. So people are weighing delay versus no delay but if you give up the prior application, you cannot be paid back to the prior application date. Whereas if I appeal and I'm eventually approved on my 2019 application, I can be paid for all those intervening years. So people, by reapplying, are potentially giving up a chunk of money. So it's an individual decision. I tend to think people should appeal and keep that other application alive, but I understand that people have specific reasons for deciding they're going to drop that and start over and maybe get benefits more quickly.
And do denial notices give you the reason for the denial?
In the most general way. So they're very unsatisfying. So they'll say, we reviewed records from, and they'll list some medical sources. And we have found that you are able to return to your past work, or that there are still jobs that you can do. But it's, people, claimants read it and feel like, this is so not true, but it's a set of general language. Mm-hmm. So it's, they sort of tell you that, it's not that much.
Okay.
Another question or no?
I think we're good.
Okay. So I said a lot of this. What if you miss your deadline? And I have specified for a hearing request, but it really is at any level. Social Security and COVID is more understanding about late filings. File the request anyway and explain what the good cause is. If you file it late and don't say what the good cause is, now Social Security will mail you a notice saying, please give us a reason. Also, they seem to give us more time to tell them good cause in COVID. So they're a bit looser on these things. One thing I did want to say though, I went through recons, reconsideration requests, hearing requests, and appeals council. The thing I didn't say is that after the appeals council, it leaves Social Security and the appeal is in the US District Court, in federal court. And that's either, like for Bronx residents, their federal court is in Manhattan. It's the Southern District. So once a case is being appealed in federal court, since it has now left the realm of Social Security and a federal court judge is going to look at it, they could reapply at that point and have a federal appeal. But while it's making its way through the Social Security system itself, you can't reapply and have it make its way through the appeal system. I hope that makes sense. And the deadline to appeal in federal court is also the 65 days. It's a bigger deal to miss a federal court deadline. And most of our claimants won't get that far, but we could talk about what the remedy might be if that happens. And if you have a specific question now, I could go through that too. This is what happens if they miss their deadline to request a hearing. And this is what if they actually miss their hearing. And that's all a bit looser now too, because hearings are being held, well, they've been held by phone for the most part for 2 years. Some have been held by video. No hearings have been held in person for most of 2 years. Only, I think next month am I hearing that any hearings are scheduled in person. So Social Security is still operating largely in COVID mode. But if a claimant realizes they missed their hearing, call the hearing office right away. The number's on the notice of hearing, or you can get it online. And that's the most important thing, not to say, oh no, and bury it and wait on it even longer. Again, a person maybe they forgot, or they lost the notice, or they didn't get the notice, or their disability prevented them, or their technology didn't work, or any number of reasons. So they will have a chance to put in writing to Social Security what their reason for not appearing was. And I really, at this point, if they have a cogent statement to make about it, it'll be granted. And then rescheduled. Hearings now, as I say, are mainly in these ways. A claimant always has the right to an in-person hearing, but it does mean they're going to wait for it to be rescheduled in person, and that if they don't mind the wait. The average wait time I see online, there are some statistics, depending on the borough you're in, is about 6 to 9 months for a hearing, which may sound long, but for those of you who've been involved with this SSI process for a long time, it used to be 2 years, and then it was down to 18 months. That's a long time. So 6 to 9 months is pretty good, relatively speaking. So a person is free to have an in-person hearing if they would rather. I get all the reasons why they would rather. Some people have no private space on which to have a hearing by phone in their home or by video, or they lack the technology, or they lack the minutes on their phone. You know, there are many, many reasons. Or they don't trust it, and they want to be sitting with a judge in a room, and they'll feel like they'll convey their circumstance much better in person. Those are all perfectly legitimate reasons. And as I say, people have the right to an in-person hearing, but it just will involve added delay. If there aren't questions to this point, I'm going to just get into an overview of what is Social Security looking at to judge whether or not somebody is disabled. So medically speaking, it's this definition that they have to meet. They have to have an inability to do any substantial gainful activity, which is work, by reason of any medically determinable physical or mental impairment. So it can be a physical disability or a mental disability, which has to last or be expected to last at least 12 months. So if it's something that's going to last 6 months, person's not going to be approved. Or obviously, if it is expected to end in death, that satisfies that requirement, the durational requirement, as we say. There are some non-medical criteria, which we talked about for SSI. It includes income, whether you have resources over $2,000, whether you have an immigration status that permits it. For SSD, it's essentially enough work quarters that you worked and paid into the system. There is this whole analysis Social Security undertakes, which they call the 5-step sequential evaluation, and that's because it is a 5-step sequence. It's available at this link, and here's a nice little chart that shows you how they think about this. And you see on the left, I have step 1, 2, 3, 4, and 5. So those are the 5 steps. And whether it's Social Security or whether it's us who are representing people at hearings, we go through these 5 steps because this is what Social Security is going to look for. So we need to be able to answer these questions in a way that helps the client. We need to be able to point to the evidence to show why the answer is the one that will get them disability. So the first one is the claimant engaging in substantial gainful activity? Are they working now? And you know what, and so this gives you the overview of the 5 steps. My next slides sort of break down each one. This is prettier than my next slides, but I'm going to move on to the next slides and just look at each step briefly. So substantial gainful activity is this term that Social Security uses for if you worked and earned enough in a month. And every year, what is considered to be enough to be considered work changes. It goes up a little bit. Congress passes the rule that says so. If a person's disability is not blindness, in 2021, SGA was 1310. In 2020, it was 1260. And I can't believe I don't have 2022 here. And I think it's 1350, but I have to look. But if a person earns less than 1350, let's say, then they're considered to not be doing substantial gainful activity. So they aren't per se barred in disqualified from SSI. If you're making that much from the very beginning, the first step, they say, sorry, you can't get SSI. The second step asks, are the claimant's impairments severe? Meaning, do they significantly limit the claimant's ability to do basic work activities? And these can be physical and those can be mental. And I have some of the basic work activities outlined here. So walking, standing, sitting, right? You think of all the jobs that we do. We're all right now, at least sitting. We are perhaps pushing and pulling. Perhaps we are reaching, carrying, or handling. To do a lot of what we do requires us to be able to see, hear, and speak. Also, it requires mental capacities. I have to understand what the work is. I have to be able to follow instructions. I have to be able to take supervision. Can I handle being around coworkers and the public? Can I handle changes? All of these are required for most jobs. And if there is a limitation of any kind in these, the impairment is considered severe. So this is what they call a de minimis standard. It can be a very little limitation to pass this test. So most impairments, if a person is diagnosed with something, they pass this test. When a judge says, nope, no severe impairments, we usually win on appeal because it's pretty hard to say that severity wasn't met because there'll be some basic work activity that was impaired. At step 3, so let's say they're not working and there is a severe impairment. The next thing is, does the impairment or more than one impairment meet or equal what Social Security has in a list of impairments? And does it check off all the boxes? And this, as you may know, is the list of body systems that Social Security has in its listing of impairments. So if I have a bad back and radiating pain, maybe I have a herniated disc, maybe it shows up on an MRI. Social Security and me as their advocate is going to look in the musculoskeletal system listing 1.00 and see if my client meets the requirements medically to say they can't work based just on that. If a person has depression, if they have schizophrenia, if they have anxiety, PTSD, all of the mental impairments, we look at mental disorders listing under 12.00. And it's all broken down. That includes intellectual disability as well. And it breaks it down smaller and smaller to say you have to have certain test results and certain impaired functioning in what you do every day. If a person does not meet a listing, that's not the end of the story. Social Security has to go on to say, okay, If the client worked at some point in the last 15 years, and they worked above that SGA level for that year, can they return? Can they go back to the work they had done at some point in the last 15 years? So maybe I was, in the last 15 years, a home health aide for 5 years and a babysitter for 5 more years. And then I did a sitting job as a telemarketer for 5 years. They're going to look at all of those jobs and say, can I return to any of them? And what they're looking at is, what is the most I'm able to do on a regular and continuing basis? Can I go do any of those jobs? So like a home health aide is considered, that's a very strenuous job, because a lot of times you're lifting people, right? And helping them transfer from the bed to a wheelchair. So that is like lifting up to 50 pounds and on your feet all day. So that might be an easy one for them to find. I can't do that anymore. And then what's the other one I said? Babysitting. That's like lifting up to 20 pounds, because you think a kid's a toddler, infants through toddlers, maybe it's lifting up to 20 pounds, and I'm on my feet all day. Well, that's like a light job, but it's a little easier than the home health aide. So if they say, well, you can still lift 20 pounds, they may say, I can go still be a babysitter. But if they say your back's bad enough, you can't lift 20 pounds, you can't be a babysitter either. Okay, that's pretty good. But I still have this telemarketing job where I sat all day on the phone and I did no lifting. If they say, well, you can't lift much weight, but you could sit all day, they may say you could go be a telemarketer again. So this is how they're thinking about it at step 4. Now, if they decide, no, you can't do any of your past work. Well, if they decide, yes, I can, then I'm found not disabled. If they decide, no, you can't, then there's one more question. Is there any other work you could do? So you see, it gets pretty broad. And then they start looking at, how old are you? How much education did you have? What is your past work, if you had any? And what's the most you can do? Can you only do a sitting job? Can you do a job where you're on your feet all day? And they do this analysis of kind of like thinking of you with your disability in your circumstance. And is there other work? And they actually have a chart where all this is laid out. So for some people, you can find them on the chart and find them disabled under these rules. You know, it gets to be, while it's in a way simple, it's very detail oriented. So at the moment, that's all I'll say about this, except that generally speaking, it's harder to be approved the younger you are, especially if you're under 50. It's harder to be approved the more education you have. And it's harder to be approved if your past work was sedentary, was a sitting job. And the reason is they will decide that you can more easily adjust to doing something else. That the older you are, the less, if you have 8th grade education or not even high school education, and you're in your 50s or more, it's going to be harder for you to find other work and make that adjustment. And I think you could feel the common sense of that. But it does present challenges for our younger claimants. It's not by any means impossible, but it's just more challenging.
Why college educated? Could you explain that?
It's just in their rules, really, that if you have college, you may also have acquired some skills that somebody who only has high school or not even high school has acquired. And if you have acquired certain abilities, it will be easier for you to adjust to other jobs. That's basically the rationale. Now, the other thing about this is it's not, is there a job out there that you want? Or, so it's nothing about what you wanted to do. So if I'm a younger person let's say I'm in my 30s and I had been a rocket scientist and I am able to walk around, but I mentally can't be a rocket scientist anymore because I had trauma and I have PTSD. You know, if I could do simple tasks and stick with it long enough during a day, they're going to say you could be a janitor. You see, it's not what you planned for your life. It's what job could you do? So that's what they're asking. So it's a very different perspective. So that's all I'll say about that. This is kind of a legal analysis question. You know, Social Security will have before them medical opinions from their own doctors, from your claimant's doctors, from the nurse practitioner, from the psychiatrist. And their doctors could be physical doctors or psychiatrists or psychologists as well. And the appropriate kind of doctor should have examined the patient and stuff. But I'll say this, they're supposed to consider all the medical evidence that's in the file and all of the opinions. It's like they should lay them out in front of them and take a look at every one of them. And for newer applications, meaning most of the ones that would be in front of us now, after March 2017, right? So that's 5 years ago. Those applications, all the medical source opinions have to be considered, and the judge has to say, are these persuasive? And that means, are they supported by the other evidence that's in the file? And are they consistent with the other evidence in the file? So if I have all the evidence says I have a certain degree of disability, I probably could function on a simple level, but I can't do complex tasks. And then I have one medical report that says this person can't do anything for themselves. That's an outlier. That's going to be found not persuasive. But if there is a level of consistency, the judge should accept the medical opinion. I'm contrasting that with an old rule for before 2017, where the treating physician's opinion was given great deference. So really, if the treating physician said they're limited in these ways, and it was more or less in line with their treatment notes, that should have been given great weight, and the judge has to listen to that. You see, it's a little less mandated now. We're still seeing how bad this is and how it's playing out in appeals. So since it's relatively new and not a lot of these cases have gone to federal court yet. So one of the main points here is under either rule, the ALJ has to consider all the evidence and is not allowed to ignore evidence or sort of cherry pick just the ones that the judge likes. All of it has to be considered and evaluated. So it's worth collecting. There are special rules about claimants who have drug addiction and alcoholism in their history. So drug addiction and alcoholism comes to be abbreviated as DA and A. Social Security asks essentially two questions. Is the claimant disabled? And if yes, is the drug addiction and or alcoholism a contributing factor material to the disability? And if yes, then the benefits are denied. Way back, I guess, in 1996, I believe, alcoholism was a disability and was removed from Social Security's rules as a disability. And this rule came into being. So essentially, if a client has I'm going to say a purely physical condition, like a back condition, such that they need a walker, and the claimant happens to be addicted to alcohol, If the client were not addicted to alcohol, they would still have the back condition and still need the walker. So you see how that's not material. And so they could be granted benefits because their back condition, it would exist either way. If a person has, well, some people in their records, you'll see like they're psychotic, but it's a marijuana-induced psychosis, then we have a problem. Because if the medical records are showing that their psychosis is caused by drug use or, an alcohol poisoning, then that's going to be denied. Having said that, let's say alcohol caused cirrhosis of the liver. Okay, but if I stop drinking, my liver is still shot, or my kidneys, and I still need dialysis. So in that case, I might still get benefits because it doesn't matter whether, at this point, whether I drink or not too much. So just to let you know, I know a lot of our clients have this issue. So it becomes an issue at a hearing. These are questions we ask our clients' physicians to answer because the judge needs a medical opinion to make a decision about whether drugs or alcohol is material in creating the disability. And the judge is not a doctor, so we need a doctor to say it. So these are the three questions we ask. I think somebody needs to mute. I'm just going to give a reminder. We have judges answer three questions. Is there alcohol or substance abuse in the patient's history? If yes, that's okay. If yes, is it in remission? Could be yes. And if it has stopped, or it's more hypothetical, if it did stop, would the disabling condition continue to be marked or severe? So you see the answer to two, if it's no, doesn't necessarily kill the claim. Though, we're always greatly relieved if we could say that a substance abuse problem is in remission for a variety of reasons, including that judges are not so, they don't look very favorably on people with substance abuse problems, and it makes it harder for us to get them to accept the claim. Okay, I think there aren't questions, so I'm going to move on. And I just wanted to point out a problem that we have found over the years that let's say my client has applied for SSI. My client has told me, no, they have not worked in 20 years. I get to the hearing and the judge says, what are these earnings on your record from last year? And, that is an unhappy moment at a hearing. So we have learned to look at the earnings record that's in the file and make sure that there are no earnings that we didn't know about. And if there are, I get to ask my client about those. And there are lots of reasons for that. And essentially, I don't know, the earned income tax credit. And if a client earns a minimal amount, it's usually like around $10,000, they can qualify for an earned income tax credit. There are lots of ways that SSI clients end up filing tax returns and self-reported earnings that don't seem to have existed. I've had clients say, I don't know, there was a guy on the street who handed me a card that said, if you're on SSI, you could get money back. So I went in, and I know, I've been handed the same card. We've had clients say, I don't know, my daughter filed something and asked me to sign it, and I signed it, but I don't know what it was. There are the people who did it very knowingly, but there are ways in which there's also identity theft. Somebody's worked on my social security number and I have no idea, but it turns up. So one thing is we should know what the earnings records say, because Social Security is going to have it and ask about it. Know what the explanation for it is. And whether or not a person was really duped and really fooled, or if they committed some kind of fraud, which we do not admit and do not ask them to admit, but we could do things to have them corrected. So essentially, at least in order for us to represent them, we say, well, okay, you need to amend your tax returns and tell Social Security to take the earnings off your records, so that you're saying, oops, this was an error. Now, the IRS might go after the person to retrieve that earned income tax credit. And, you know, that's another thing, but they're avoiding fraud and they might get their SSI benefits if they come clean, or just make the correction of a mistake that happened in some other way. Judges at hearings are not supposed to delve into this all that much. That's what SSA says. I've had clients with earnings turn up, and then we have done what we call an amended onset date of disability. So the earnings stopped 2 years ago. I was claiming benefits for the last 4 years. We amend the onset of disability to say, okay, we'll say that the disability began 2 years ago when work stopped. And these are things we do in concert with our clients, and it's their case, so they would have to agree. So this is one of the thorny issues that I'm really saying all this just to say, if you're helping somebody, look at the earnings record, because there might be something there that the claimant should know that they have to deal with. I think largely I've gone through the non-medical eligibility criteria for SSI. Here they are again. Here is a thing that's happened. You know, last year and the last 2 years, lots of people got pandemic-related payments, federal payments. A lot of the unemployment insurance benefits, and then they got extra unemployment insurance benefits and all that, which was very good for people. At first, Social Security was saying people on SSI were overpaid due to those benefits, or not eligible for SSI due to those benefits, but Social Security has changed. I think it helped that Joe Biden became president, so they have had a turnaround in their policy. So if any of your clients was denied for this reason, or their benefits were stopped for this reason, or they were told they were overpaid due to pandemic payments, Social Security is actively reviewing on their own all of these cases to correct it. I think if you know this happened to your client, though, I would recommend that they contact Social Security and let them know that their case needs to be reviewed. One way to do it is at the 1-800 number. Probably a better way to do it is at the field office. And those numbers and fax numbers are online. I suppose it's possible to file a request for reconsideration online, and that would at least put their issue officially in front of Social Security. But we have had clients that we've done a couple of phone calls for, and it gets rectified. So Social Security isn't resisting this problem. I think the volume might be great, so it's taking a while. What is the financial assistance that I'm talking about that shouldn't count against SSI? Those economic impact payments, state stimulus payments, unemployment, some emergency assistance for COVID funeral-related payments, rental, and the last one, rural housing, rural rental assistance wouldn't really apply to New York City, but there's a wider list of examples at the link I'm giving there. And then I think we're close to the last topic, which I know your clients have sometimes, because you have a lot of clients who are already on SSI. Sometimes those claimants will get a notice that they were overpaid. They got too many benefits. If that's the case, the claimant is supposed to get a notice in writing. It should tell them why they were overpaid in a more specific way, that they have resources. It'll often list the bank account, or that they have income and what the source of income is. And it will also give appeal rights and time limits for appealing. If a person gets an overpayment notice, they can file 2 different kinds of appeal. One is called a request for reconsideration, which is a term you're hearing a lot today, because it's the kind of appeal that can take care of a lot of issues. And in that request for reconsideration, the person is saying either I was not overpaid at all, or the amount of the overpayment is wrong. But you're contesting the overpayment on the merits, like in a basic way. And they file this request by filing a request for reconsideration form, or you could do it online completely. As an advocate, you can also do it for someone else without being their official representative. So if there's somebody with you and you're more able to fill in their name and address and say, I wasn't overpaid, it's an easy form to do, and it doesn't implicate you in an ongoing way. Another kind of appeal that people can file is a request to waive the overpayment. And this is a little different from the other one, because if I file a request to waive the overpayment, I'm essentially admitting that the overpayment happened. I'm not saying, no, it didn't. I'm saying it may have happened, but it wasn't my fault, and I can't afford to pay it back. And so that's essentially it. And even if it happened, we have had clients who can show it wasn't their fault and they can't afford to pay it back. SSI recipients are per se under the law judged to be unable to repay. So you basically just have to show it wasn't their fault. That's not the easiest thing, but it is possible. And they can also file this online. In lieu of that, let's say the reconsideration was unsuccessful, the request for a waiver was unsuccessful. People can have hearings, but ultimately, if they're not successful, if an SSI recipient will be recouped at a rate of 10% of their benefits. So if I get $800 a month, normally they're going to take 80 out. I know every dollar counts, but it's not that they take all of the benefits. It is possible to ask for a hardship reduction of that. I'm not sure how readily Social Security agrees to that. Are there other questions at the moment? You're muted right now. Okay.
Thank you. I have a bunch of questions I've been compiling throughout that we didn't get to for whenever we're done with.
So I'm going to say that my last slide is this, that you can send me questions. You can have clients call our Access to Benefits helpline. If they have trouble getting through, I would love to know that. We're having some glitches these days, and I don't want people to be sent away or have too much trouble. So those are the 2 ways I would say most easily is you can email me with questions, or even if you had a client to refer and stuff like that. So I'm done.
Thank you so much, Anne. That was amazing. So much information. And thank you for sharing your contact information with everyone.
Thank you. That's very nice. Very informative.
Great.
Thank you so much.
You're welcome.
We do have a few more questions I'm going to go through.
Thank you.
You're welcome.
Does SSD cut or end when a person becomes eligible for retirement benefits?
it converts over. So the person essentially gets the same amount, but it just comes from a different pot of money, and it just becomes retirement benefits.
If someone's applying for SSI, do they also have to apply for SSD?
No. If it's known that the person has no work history or an insufficient work history, like you basically have to work for 10 years on the books, then you don't have to. But if Social Security sees that you have enough earnings, then you do have to, because the federal government wants to pay you out of the pot of SSD if they can, rather than the pot of SSI.
A few more questions for everyone. I just launched a quick poll, if you wouldn't mind filling that out. All right. If you are disabled at a young age, can you apply for Medicare? That might be a question for someone else.
Well, beyond the one sentence that I'll say, it would be a question for someone else. Medicare attaches to Social Security disability payments. So kids generally get SSI, and that would be Medicaid. But if a child was being paid on a parent's account as a disabled person, it's conceivable that they would get Medicare. That's all. Like there really are experts. Like people could probably give you a whole training.
and we do have some trainings coming up, so I'll share those links. Okay, a few more questions. Does the $2,000 cap apply just for SSI or for SSD as well?
Only for SSI. So SSD, SSD conceives of us as maybe you're a person who's worked for 20 years and you have a retirement account and you can't work now, you can get disability payments and not have to drain your retirement account. So SSD, you can have resources. I could have $1 million. But SSI, you cannot have resources above $2,000.
Okay. Does a homeless shelter count as a resource?
No.
That it replaces the need to pay rent and buy food?
Oh, I see. No, that's a slightly different question, which is a very good question, because social SSI, which I didn't say, thanks for saying this, is meant to pay for food and shelter. And so if Social Security thinks I have no shelter costs, they do reduce my SSI by 1/3. If I can show I have the obligation to pay for rent or shelter in some form, they'll give me the whole SSI amount. So it's conceivable that they would reduce the SSI, but I haven't really heard that people in shelter are having SSI reduced by 1/3. See? Yeah.
And what happens if the applicant wants to appeal past the 65 days? Do they need to submit another application?
If they want to appeal and they're past their 65 days, they have a choice. They can file a late appeal and describe what their good cause reason is. Or they can say, oh, well, I am going to file a new application. One possibility, if they decide to file a new application and it's within a year of the last denial, they can ask Social Security to reopen the prior denial. So if it's within 1 year of the last denial, Social Security can use its discretion to say yes or no, we'll reopen it, but it's totally worth asking.
Okay. In relation to legal aid, can people refer clients who need help filling out the paperwork for benefits?
We don't have, unfortunately, the resources to do the paperwork at the application level, generally speaking.
Okay.
And we just had a whole conversation about this earlier, and we don't know many. There are community-based organizations, some of which do it, but there aren't that many. Unfortunately, we have grants to really do the appeals part.
Okay, we're going to run through just 2 more questions. Can you appeal the same decision more than once? Or I guess the answer could be, or the question could be, should you appeal it more than once?
More than once. No. And the thing is this, I got an SSI denial at any level, my application, and I file my appeal. They get to decide that at reconsideration. If that's denied, I can file an appeal for a hearing. If that's denied, so you never file an appeal twice at the same level. You go to the next higher level of appeal. Now, a successful appeal often, like after it, like maybe the ALJ at the hearing, the administrative law judge will say, I disagree. I think you're disabled. I disagree with the denial, so you're disabled. Great. If not, he says, nope, unfavorable decision. I go to the appeals council. They might say, I think the judge made mistakes. And they won't often grant you the benefits right then. They'll say, so you should have a new hearing. So you get a new hearing. And if I get a new unfavorable decision, I do get to appeal that again. Even at the federal court level, they'll very rarely say, we're granting you benefits outright. They will often say there were many errors made, you get a new hearing. So you see that you can't appeal the same thing twice, but it can keep going. And you can have new chances for new hearings and then new decisions and then new appeals.
We have one more question if you were able to stay on for another minute.
Yeah.
And I also just want to let everyone know, because we have a lot of questions and that's great. We are trying something new in a few weeks. On April 21st, we're calling it an Ask a Lawyer session. And this one's going to be about this topic specifically. So if you have questions related to Social Security benefits, you can come to this training and Anne will be there to hopefully be able to provide just a little more information. It's not legal advice, but hopefully that will be a resource to you also. I'll send that information in the chat. And as I do that, Anne, do children who are autistic qualify for SSD?
Maybe. So there is a mental health listing. I showed you the listings for adults. There are parallel listings for children. So there's a mental health listing for children. And in that is autism disorder. And a lot of the question then goes to the severity of it. Like there are kids who are on the autism spectrum, but are functioning pretty decently. But then there are children with autism that they're just not doing well socially or learning or paying attention. So it is one of the listed impairments, and it's all a matter of severity.
And the last question I have is, I think that people who were working used to get SSI notices about how much you would get if you retired at a certain age, but now SSI has stopped mailing out those notices. Do you know if people are able to start receiving those notices when you are over the age of 60?
Oh, that's interesting. I think they did stop sending them. What Social Security says is they want you to sign up for My SSA on ssa.gov, and you do an online account, and then you can see what your history, your work history, earnings history is, and your projected Social Security amounts. I don't think they're sending them out in hard copies anymore.
Okay.
Yeah.
So send that link so that people are able to.
Yeah. So ssa.gov, and then you can see that there. I think it's like there'll be a menu on the left and it's like my account or my SSA or something.
Okay. All right. Those are all the questions I have.
Okay, great.
Thank you so much.
You're welcome.
I'll follow up with the recording and the slides and some of the resources mentioned, and as well as our other events coming up. So see you soon, and thank you so much, Anne.
You're welcome. Thanks for being here, everybody. Thanks, Tess.
All right, good night. See, I got that one right.
Yeah, you did.
Bye.
Bye.
Thank you. Bye.